Hello, everyone. Welcome to our Inventors Network December meeting to 2020. Our speaker today is Tyler Dunham. He's an attorney. His office is in Dublin, Ohio. My name is Mike Jacobson. I welcome you to this presentation. Tyler's been practicing patent law for 13 years with both a mid-size intellectual property law firm and is now running his own firm with his partner based here in Columbus. His background is in mechanical, electrical engineering, and he advises many types of clients from independent inventors to mid-sized corporations on invention protection, strategy, and enforcement. He also sits on the board of directors for Wave, a nutritional food tech startup, and helps advise several other startups on proper resource allocation for their intellectual property. So today's topic is when not to file a patent. Tyler, the floor is yours.
Thank you, Mike. I appreciate it. This is my second time being able to be with the Inventors Network, and I just want to thank Mike for inviting me back. It's a really special group that he's been curating here, and we're lucky, I think, here in Columbus to have something like this and to share. And I'm sorry that we can't be in person and chat and network like we normally do, but we're still going to try to share information with each other and see if we can help everyone succeed. So today, the topic was when not to apply for a patent, which is a little sacrilegious for a patent attorney to come up here and give. And I think Mike was, I told him it might be bad for business, but I think in reality, a good patent attorney needs to know when sometimes it would be better not to file a patent, or even if the patent is not an option in that case. So today we're going to kind of talk about situations when you might not want to file a patent, whether that's you're not permitted to by law, or maybe strategically it would make more sense not to file a patent. So I'm really going to walk through different industries and different technology types, and we'll talk about the considerations for each of those. And the one I want to start with is one of the most challenging, and that's software. There's lots of different types of software out there that does a lot of different types of things. So there isn't really a broad rule that we could give for whether or not, if you have invented some new software, that you should be filing a patent application for it. In general, if what you're doing with your software is what we've done with software for many, many years, which would be analyzing data, making calculations, giving results, and it's purely going from computer to computer, that's largely viewed as being unpatentable now. Now that we have the invention of the computer and all the amazing things that a microprocessor can do, doing more calculations or looking at data in other ways or presenting it in other ways is largely viewed as an obvious thing to do, although we don't consider it obvious, we consider it not to be patentable subject matter. Now, that's not the case for all software. There is some software that you could still file patent applications for, most notably AI techniques. Artificial intelligence ways of solving these problems is very new, very unique. It's not obvious based on just the functionality of a computer. So those types of techniques are still patentable, and you might want to consider a patent application for artificial intelligence. Another field within software would be your blockchain, or your improvements to the way that the computer actually is going to store data and then recall that data. Those improvements are still held to be patentable. And then I would say another big exception would be if your software works with any piece of hardware, whether that hardware is unique or whether that hardware is known, but as long as it works with the hardware in some way and that's included in your patent claim, you could have something patentable there. And an example I would give would be maybe a sensor that existed in the past, but you have a new piece of software that works uniquely with it. That could be patentable subject matter. What seems to be the bright line for the courts is ones and zeros moving over to ones and zeros. If you're not touching any piece of hardware, unique piece of hardware other than a generic computer, that's largely going to be viewed as unpatentable. So a lot of times we try and wrap in a piece of hardware into our patent when our software works uniquely with that, and that's what we're really going to be focusing on in our patent. Otherwise, generally speaking, I think people should focus on copywriting their software. That's really where most people will go for that level of protection. unique user interfaces, I think, could be the subject of design patents, actually. So if you have a user interface that is particularly unique for its aesthetics, those could be filed in a design patent. But otherwise, copyright and maybe trade secrets would be the best way to protect your software. The next category that I have here is recipes. There's certainly a lot of people who have created some great foods, some pastries, some bakery goods, and they're very unique recipes. And they may want to expand those businesses, grow them further, find investors, do different things like that. And they want to make sure that those recipes are protected so that no one could take them. And the sad fact is most recipes are not going to be patentable because they involve usually a combination of known elements that do what we think they're going to do. So even if you've found the greatest cookie recipe ever, and it's the most luscious, amazing cookies you've ever had, it's likely some combination of flour and baking soda and eggs and butter or whatever doing what we think it normally does. When you bake it, it makes something delicious. So by and large, all of those combinations of ingredients are not going to be viewed as patentable, with the notable exception of if you've come up with something new or an ingredient that in the past behaved in a very specific way, now it's doing something very unique and different that was not expected by people of skill in this area. Now you may have something patentable. I would say that's pretty rare, not very common. But if you came across a situation like that, you could be able to patent this particular recipe only because maybe it involves a unique ingredient or an ingredient that's not acting how it typically does in most other settings. You're really better off as trade secret. Again, there's plenty of recipes out there that have been protected for over 100 years with trade secrets, certainly Coca-Cola being one of the most notable ones, certainly many others. The next topic I want to talk about was a process. And a process can be many different things depending on the industry that you're in. It might involve just a combination of time and temperature that's applied to something in a very specific way. It could be a specific combination of chemicals that are applied in a specific pattern in certain volumes. It could be just the order of steps in that they're performed, or it could even be a special machine that's doing this process. And each one is going to be a little bit different type of patent application. But with each one, what we really want to look at is whether or not this product could be reverse engineered from looking at the end result. If we could figure out the process by simply looking at the product. If that's the case, and you feel that that would be easy for your competitors to do or other people to do, then you may want to go for the patent application in that situation, because once they discover what the secret sauce is, there's nothing preventing them from using it themselves. If you feel that it's going to be very difficult for them to reverse engineer, it's the type of process or it's a combination of variables that would be very, very hard to sort of decode and figure out exactly what happened there, then you may want to forego the patent and leave that as a trade secret. You can't simply make something a trade secret. It is created through various steps that you do to protect it. So whenever we enforce trade secrets in court, the first thing that a judge is usually going to ask for is, let me see all of the processes and procedures and paperwork and passwords and everything that you use to control access to this. It's going to be very, very important that you have all of those in place and that they were started years before the litigation in order to succeed in a trade secret claim. So I wanted to make sure that I note to everyone that you can't just deem something as a trade secret because someone stole it. You need to treat it as such for years before hopefully this ever happens. So a lot of those processes, really what it comes down to is whether or not you feel your competition would be able to reverse engineer it. If you think it would be very difficult or impossible, then perhaps leave it as a trade secret. One of the other things I wanted to mention about processes in general is that usually they're happening behind closed doors. They're usually happening in a factory, in an R&D facility, in a place that we don't normally get to see. And so if you have a patent on a process like that, it could be very difficult to actually enforce that patent because I don't really know exactly what they're doing. And we would have to base our lawsuit on, decoding this from an expert's perspective. And that could be full of holes and could be highly questionable. We don't want to file any litigation unless we are very certain that we have the facts to support it. And I can't see the machine or inside the factory or any of the steps until we institute litigation and we have discovery and we can see the documents and we can get in there. But there's a long, long road through litigation in order to turn that over. So another thing to consider when you're allocating resources for patents is process patents that happen behind closed doors might not be as valuable as some of the end resulting apparatus patents or design patents or things like that that are facing the customer, and we can see right away whether or not we have infringement. And that's another factor to consider if you're thinking about whether or not to file on a process. This is related to process. The next one here is chemical compositions. Their chemical compositions are obviously patentable. They must obviously survive all of the typical patent constraints in obviousness and things like that, but they are patentable subject matter, no question about it. And the question is, do you want to patent that? And would it be worth it? And again, I would do the similar analysis as to if an expert would be able to decode what that chemical composition is, working backwards, then you may want to try and file the patent application for it. If it's very, very difficult for them to determine exactly what the composition was and the amounts, then you may want to leave that as a trade secret, which could last for hundreds of years. Even if you're successful with your patent, remember, it does have a term, it is going to expire. So if you're really, really, really thinking about the long haul for your company, the trade secret's probably the better route. They are more difficult to license and sell, things like that, but they do provide other benefits. The next point I wanted to make was just about fast-moving industries, and this could be chemical, this could be electrical, this could be anything. But if your industry is extremely fast-moving and a product is launched and maybe only has a life cycle of 2 to 4 years, by the time your patent issues and you have it in hand and you can use it, the life cycle of that product is wrapping up. And you have to really think about whether or not that's worth an investment when things are moving that quickly, and whether or not that money could have been used in other ways. I think some of the common areas that you might see this in is in electronics a lot. We see LEDs and LED circuits turning over, it seems like every few years. Microprocessor technologies, software applications, some of them do stand the test of time, but many apps, they exist for a few years and then users have moved on to a new app. So, filing for a software application, really by the time you obtain that patent, you may be already onto your next revision or a different application altogether. So when you're in a fast-moving industry, I also think you should consider maybe not filing a patent, because the time that you would have to actually utilize that patent might be slim to none. So that's another thing to consider. I know I've beaten this drum a lot. I just wanted to mention one more time, when you have two possible paths and you're really trying to determine whether or not you should file your application, it really, I think, comes down to evaluating your competition and their skill level and whether or not they would be able to reverse engineer it. And it goes across different product lines, but I just wanted to beat that drum one more time. That is kind of my golden rule for drawing that line and what we're going to patent and what we're not going to patent. It's usually that question. Some of these last ones are usually what we would call sort of unpatentable subject matter based on statute. It's very clear these are not patentable, but I think it's unclear to the general population. They would think it should be, and I think they're surprised sometimes. So let's say you're digging around in your backyard and you find a new element, and it happens to be a metal alloy, or it can be incorporated into a metal alloy, and it's going to create the lightest, strongest metal that we've ever seen. Pretty incredible discovery, and it might have some amazing applications. So perhaps you want to file a patent application on this material that you've discovered. And unfortunately, because you discovered it and you didn't really invent it, you're not going to be able to patent that. What you could do is apply that material in some way to a part or process or a machine, and patent that, the use of the material in that application. While that would be patentable subject matter, you might struggle with, for instance, if that is a very light and strong material and you're using it in an application where it needs to be very light and strong and it is performing exactly as it should, you could see a rejection of that being obvious. Even though you're the first person that has ever done that, it's really just because you happen to discover this element and it does exactly what we think it would. There would probably need to be some kind of a unexpected result or strange thing that's happening in the testing and analysis that would support a unobviousness argument to the USPTO. But I think sometimes people think if they discover something, they could then patent it and protect it. And the patent laws really aren't made for discoveries per se. They're really made for inventions. And those are two different things. The next one is a mathematical equation or an algorithm. Physics, equations, anything that explains the natural world, all of those things, even if you discover a new algorithm that explains some unbelievable physics or something in the physical world, that algorithm and equation on its own is not patentable. Those are considered to be abstract ideas that haven't actually been embodied in a real thing yet. So the equation itself is not going to be patentable, or the algorithm itself is not going to be patentable. What you would have to do is tie that into something in the real world, whether it's a machine or a sensor or a autonomous driving system or something like that. You're going to need to apply it to something real. The most famous example that we have in this world for patent attorneys is there's an equation for the curing of rubber. And that equation was used to control a rubber curing machine by a tire company. They decided when they would close the mold, when they would open the mold, what temperatures they were going to hold it at. And all that was driven based off this equation. And the court said that that was fine because it was an application of this scientific principle and description of the natural world in something that we created to produce a physical, thing that was an improvement over previous tire curing technologies. So that's usually the case that most patent attorneys will go to try to determine if your algorithm would satisfy the patent requirements. It would need to be used to control a real thing that would need to be unique in the world. The next one is methods of doing business, which is a strange one, I think, to a lot of people, but you would be surprised the number of patent applications that have been filed on these types of things. A lot of times what the courts are referring to when they say your patent is a method of doing business and it's not going to be allowed is they're talking about maybe financial closing processes where a document is sent to one party and they sign it, another party is sent to a third party and they sign it, and then between the two of them some money goes to even another party and they hold the money, and all of these different ways of basically methods of doing business. You might be the first closing company that ever done it this way. You might be the first investor who's ever decided that, well, when I have this much risk in this stock and I have equity in this stock, I'm going to move assets here and there. You may be the first person that's ever done that, but because it's really just a method of doing business, it's not really viewed as an invention per se. It's not viewed as the progress of science and the arts. It's really just a business method. And for many years, people would incorporate those business methods onto a piece of software. So there's a lot of stock trading algorithm softwares out there, as well as tax avoidance algorithms. And once they put that onto a computer, they said, well, now I'm on a computer and I'm doing these advanced techniques that could never be done by a normal person. We're doing calculations much faster and we're getting results that no one else could get. The court said, no, it's just a method of doing business and you're just using a computer for exactly what a computer does. So there's nothing patentable there. So those are considered methods of doing business and they're not considered patentable, even if you wrap them into an app or a piece of software. The next one is mental processes, which is kind of similar to the methods of doing business. It does have some overlap with the investor crowd. There were method patents where you would calculate the risk of one investment versus the risk of another investment, and then you would decide where to put your money. Well, that's what investors do, and that's what financial advisors and planners have done for many, many, many years. So just automating that on a piece of software is not going to make it patentable. And by and large, the mental process of making that decision of which one I should invest in is not patentable subject matter either. It also comes up with doctors in medical diagnostic technology as well. And I will talk about that next, because this is the last big section I want to talk about as far as a broad technology-based topic, and that's biotechnology. This stuff has been moving so fast in the last few years with both the ability to, map the human genome and have computers really being able to isolate all these proteins, try millions and billions of different combinations till they find what works. It's really been amazing. And I think, like always, the law and Congress is way behind on how to actually protect these things. So we have Supreme Courts holding that essentially things of nature that occur naturally are not patentable, okay? The next question is, well, how does that apply to these very complicated and sophisticated techniques in isolating certain genes from DNA? So there are companies who have figured out how to pull out these individual protein strands and find what strand of DNA or pieces of DNA might be a trigger or a marker for certain types of disease or chronic illness. The question has become whether or not that isolated gene is something that occurs in nature, or is that something that was man-made? So the position of the companies who figured out how to isolate the gene have said, well, perhaps the gene does exist in nature, but it doesn't exist in its purified, isolated form. It's always wrapped in all these other proteins and these very complicated molecular chains. We have isolated it. It took a lot of work and scientific experimentation, and it provides a great benefit, and that should be patentable. Well, the Supreme Court does not agree, and they have felt that basically those are still natural elements. You have just, isolated them, simply kind of almost like taking iron ore out of the ground or something like that and purifying it into other metals. The Supreme Court does not view that as being patentable subject matter, and it's caused some real issues, I think, for biotech companies and their investors. Another big problem that it's causing is with diagnostic tests, because you can use these algorithms to determine, obviously, if you have a certain pathogen or virus or whatever, and it's very, very useful. The problem is that the last step of a lot of these diagnostic tests is sort of determining that there is some sort of infection and then administering some kind of a treatment to it. And again, we're now getting into what a doctor does. So while we have given this doctor amazing tools where he can now see, DNA or pieces of DNA, how different is that from a doctor who can see that you're coughing or see that you have elevated blood pressure or see other vital signs about you and then determine that you need some level of treatment? So these diagnostic tests, the end step in determining whether or not you need to administer something and then the quantity that it needs to be administered to has also been found to be unpatentable subject matter, because that's just what doctors do. That's what they're trained to do, and trying to patent that is not permissible. And then this last one I find to be one of the most interesting, and that's in cloned animals. So we've had the technology to clone animals for many years now. Other countries have certainly done it. There are lots and lots and lots of ethical considerations about it, which is for another topic, certainly. But on the patenting side of things, that was a true achievement in science, to be able to clone an animal. I think commonly what they were doing was goats. I want to say that the cases came up to the Supreme Court. They had, or a sheep perhaps, and the case came up to the Supreme Court, and the argument from the cloning company was, this sheep has exactly the same DNA as this sheep over here. He is a perfect clone, and that kind of stuff does not exist in nature. If he was going to breed with another sheep, the resulting DNA would be a mixture of the parents. And so they don't exist in nature, but the justices disagreed. And they said that sheep standing there is sheep just like that sheep. It's just a copy of the one that already appeared in nature. And so cloning technology is also not patentable, because you're just duplicating what we already have in nature. Now, that's really a patent directed to the clone itself and not necessarily the process that they went through in cloning. So my understanding is that the method steps that they went through to produce the clone was patentable, but you can't basically have a patent on any clone of a sheep or any clone of an animal or a mammal. So it's a really interesting field. I wanted to mention too, a lot of this stuff is changing monthly. It's a case-by-case basis. We just wait to see each case as it goes up to the Supreme Court or the USPTO, and how are they going to handle it. So, we could talk in the mid-late winter or even spring, and a lot of these may have changed. Or hopefully within the next couple of years, we could see some real action from Congress, and we can rewrite some of the patent laws so it's clear that we are protecting good, valuable technology, and we're leaving out some of the business methods or other things that maybe clouded the patent office for many years. So this last point is just a fact pattern that might come up with you in your business or while you're inventing things that could prevent you from filing a patent, even though you satisfy all these things that we've talked about so far. And that's what we would call the on-sale bar or the public use bar. If you use your invention publicly or offer it for sale in any way prior to filing your patent application, a clock begins to tick. And you have 12 months to file your patent application in the USPTO, or else you're forever barred. So it's not uncommon for me to get a call from someone who has run a nice business, they've sold product and it's going well, the competitor has started to copy or knock off the product, and now they would like to go to the USPTO and file a patent application. But I explained to them they've been selling it for more than a year. We simply can't do it. You would have had to do it years ago. And I think it's frustrating to hear that. But the reason we do it is because we don't want people to simply file patent applications on successful business technologies. We want people to share their discoveries, share their inventions. That's the whole point of the patent system, is show us what you've discovered so we can learn from it, and then we'll give you a limited monopoly for a certain period of time for sharing that. So it defeats the purpose if you wait to share until you're sure that you're going to make money. So that has been frowned upon for years. The other interesting catch that you have to pay attention to, especially if you're going to file any international patents, is they typically do not give you this extra 1 year. Most foreign patent offices are what we would call an absolute novelty patent office, which essentially means that anything that was done in public prior to your filing is going to be used essentially as prior art. So even though it was your own invention and your own presentation or your own offering on your own website, it will be used as prior art against you, or will just be an absolute bar to your filing in that country. So for any of my clients who want to file anything internationally, I always advise that we file something, even if it's just a provisional application, before you go publicly use this or offer it for sale in any way. That's just the best way to stay protected. So that's pretty much it. I really appreciate everyone's time. I hope everyone is safe out there and you got something very useful out of this. I believe that Mike is going to give my contact information again at the end. I didn't produce slides for this. I apologize, but anyone who has any questions, please send me an email. I'm happy to chat and explain. I'm really happy to be here, and I look forward to seeing everybody in person soon and getting back to some kind of normalcy. So thank you.
Thank you, Tyler.
That's what a hard habit to break.
I know. Congratulations. We have this certificate of appreciation, which confers an honorary membership for 1 year. And everybody, thank you very much. We really enjoyed your presentation. Everybody out there, as I always say, invent and prosper.